Hello, hello, hello. I wanted to let that sit there for a minute. How are you all doing? I know, it's been forever again. I'm not even going to lie to y'all this time and say, oh, I'll be around because God only knows whether or not I will be here or not. But today, what we are going to be talking about, you guys know I had to come on here and discuss with you all the latest and greatest as it is occurring, okay, as it is occurring with this Bishop Bernard E. Jordan lawsuit against Larry Reed and a host of other people. It really is important for me to have this discussion with you all. And so we're going to talk about the lawsuit. We're going to talk about some things I'm not seeing people talking about, one of which is the move. There has been a change of venue, which is going to affect this case tremendously. And also, we're going to talk about the difference between free speech, exposing what's wiretapping, and all of these things. Now, listen, I am not an attorney, nor am I claiming to be an attorney at all. Okay. I'm not claiming to be that at all. So, what I have done is we've done a lot of different, this, that, and the other, and we've done a lot of research. And so I have some legal precedents here. This is not legal advice. I am not making any type of accusations or anything of that nature. So I don't want nobody to take it like that. I ain't got time for that BS. And we're going to get into some things. So let us play our intro and then we're going to get started. Hello, welcome back, welcome back, welcome back, welcome back. I need to be sure I'm turning my monetization on. Again, hello everyone. My name is Dr. Lisa Barama, Doctor of Divinity and of Metaphysics. And so I'm not a JD. I don't have a judicial doctorate. So, don't come at me for all that kind of stuff. But I'm really interested in having this discussion with y'all, because I feel like it's very, very important that we talk about these things. And I have noticed, what is going on? Oh my gosh. Let me tell you something. I haven't been on here in a while. So it is a tad bit strange for me to see some of these new things going on in the background. So let your folks know that I'm here. Let them know, and moving and change of venue. That's not something people are talking about. People are not talking about the change of venue. And I think that's extremely important. Okay. For those of you who know what's happening already, and for those of you who don't, I'll give you the brief rundown. Um, Bishop, last week, actually officially on the 10th, and then there was a kind of a notification on February 10th that there was going to be some filings happening. And then the actual original complaint was filed on February 12th with an amended complaint on February 13th, which is what everybody's been kind of reviewing. So, oh, you know what? I need to put my banner up here. Hold on. Hold on. Um, I need to put a banner up here. Bear with me because you know what? Um, let's see. Let me see here. I need a banner. I need a banner for my stream because what I am not gonna sit here doing is I'm not gonna sit here and have y'all coming and trying to add me to anybody's lawsuit. Because I don't have a written ticker. Um, I I have no dog in this fight. I have no dog in this fight. Um, I had none whatsoever. Okay. And here we're going to put this ticker on here because this is legal commentary. I'm not a lawyer, but I am creating my own legal commentary. All right. So we're going to scroll across. We're going to do that. We're going to put that down. I guess at the bottom is fine. And we're going to do it slow, and we're going to add banner, and we're going to put this up. All right, here we go. This is legal commentary based on publicly filed federal court documents. Based on publicly filed federal court documents. Okay. That's all it is. I am very interested in this because this yet again is another opportunity for us to discuss um, whether or not something is defamation or it's free speech. And the reason why I think this is extremely important that we do that is because if we're going to sit here and have be able to exercise our First Amendment rights and so on and so forth, we need to be able to make expressions. I believe, as long as they're not harming anybody, we need to be able to make expressions, and talk about things. And if we get information um, that is pertinent, right, and that is about a specific individual that is a public figure, we should be able to have those conversations. Now, as long as it doesn't cross the line of defamation. And so we're going to talk about what defamation is. We're going to talk about a lot of this, right? All of this, right? We're going to talk about what the difference between free speech and defamation is. We're going to actually talk about wiretapping a little bit, which is not something we've had a lot of ability to discuss. So I'm kind of excited for that in and of itself. And we're going to go on and get started here. So let me go on and make sure that everything is going. I wanted to go live on X as well, but it doesn't look like I'm live over there, which is unfortunate. But I did post it. Okay, so let me bring this up. So I'm not sure how many of you all know. Hey, Katrina, how are you? Yes, you haven't seen me in a while. Listen, y'all, also, I'm eating a little bit of toast. I'm getting ready to go to bed as soon as I'm done with y'all, but I had to have me a little snacky snack, and I really didn't have much, so I went ahead and did this. Everything is good. I will tell you guys everything that's going on. Hello there. Hello, how are you, Lynn? I just got back recently. I got back last week. From a speaking engagement in Vegas. I'm getting ready to arrange for another in-person engagement out in New York City. We will talk about that. That's probably going to be in April, but we're going to need you guys to get your tickets before then. I will be collaborating with someone else on that. So there's a lot going on. Getting ready to launch my new channel. Business is going well. We'll talk about all that. Plus, not for nothing, let me just tell y'all one thing real quick. I know it's probably rude to eat while but I'm sorry. Y'all gonna have to just forgive me. It's Sunday night. I'm tired. I've been working all weekend. Listen, this is the start of my Saturn return. Now, for my astrology girlies, you know that means for the next 2 to 3 years, a lot's going to change in my life. Now, your second Saturn return is a heck of a lot better than the first one. So we'll be talking about Saturn return this week. Saturn return. So all of my Saturn and Aries girlies and guys, hey, we're all having our Saturn return. So we're going to talk about that. We're going to talk about the Saturn and Neptune conjunction. We're going to talk about the fire horse. We're going to talk about a lot of stuff. There's a lot to talk about. But tonight, we're going to be giving layperson legal commentary on publicly filed court documents. So let me go here, and I want to, let's go back. Oh, crap. Continue. I'm going to have to log back into Pacer because I want you guys to be able to read this document. Anyway, do you guys know what we're talking about? Let me bring this up. I don't know if you guys will be able to read it, but let me bring it up anyway. Okay, let me try that. Amended Jordan complaint. Okay, here we go. So we're going to bring this here. And we're going to do the amended Jordan complaint. I don't know if I can zoom in. Can I zoom in? See, this is why I don't sometimes like um oh my god, I don't want that, for God's sake. Yes. Okay, find cases. Hang on, gang. Hang on. Hold on. 1142 search, and this one, and we're going to view the documents, and we're going to run the query, and I'm going to bring it up over here because I think it's going to be easier. Let me open up the amended complaint, view document, and I already paid for it. All right, here we go. Let's drop this, and then I'm going to instead share a screen, and then we're going to share this tab. All right. And let me make sure you can see this perfectly fine. I like it. I like it. I like it. Let's see if we can't make it even bigger. Okay, that's good. This is good. Yeah, you guys can see that? We're good. Okay, here we go. Listen, tonight we're not gossiping and we're not speculating. We are not really in anybody's business. We are not. Hey, Anna Alicia, we're not in anybody's business. Okay, I don't. We don't have time for all that. What we're doing is we're going to be reading the federal court documents. I'm going to be giving you a little bit of, hey, this is what we think, and I'm going to be also referring to some other legal precedences or legal terminology, and we're just going to kind of look at it and then see what we think about it. But I'm wanting to talk about this in the framework of this is a continual issue that we have in the church, right? We have it where there may be some things happening behind the scenes. There may be some people doing some things that they shouldn't be doing. There may be a lot of this other stuff happening, and then we don't really want to talk about it. And so sometimes it's true that everything in here right now, this has not been adjudicated. This is a civil case. There's been no discovery, no interrogatories, no nothing. We don't even know if this is going to court, into trial. It's been filed. That doesn't mean that the judge is going to take this up and say, yeah, we're going to move forward with this. So there's been no adjudication in this case. Okay. But this is all stemming from what was a union between Bishop or Dr. Larry Reed of Larry Reed Live, and Bishop Bernard E. Jordan, okay, of I think it's Bernard E. Jordan Ministries. Anyway, Bernard E. Jordan has been a prophet in the Church of Christ specifically for quite some time, very well known. He and Larry Reed had a multi-year kind of working relationship. He was on Larry's channel quite a bit. He was on the television show that was on BET. And then last year sometime, that relationship stopped, broke off, da-da-da-da-da. We're not going to relitigate all that and talk about all of that again. But as a result, then there is this fighting between the two. I don't want to say who did what, why, what, and when, what for. But what really happened, split happens. I'm breaking away. There's like some minor accusations and a little bit of mudslinging. Then there's the other one going on this kind of tour de ops, right? To all of Bernard Jordan went to all of Larry's ops on YouTube. Let's just call a thing a thing. It is what it is. Now, right, wrong, or indifferent, that's what the hell happened. And also then Manasseh, his son Manasseh joined him. Why am I even going through all this? Let me put this down here a little bit so I could talk to y'all. Why am I going through that? Because y'all need to know the background. At some point during all that stuff that was going on, and you can go to various channels across YouTube, King Jives, Mad Church Disease, Thais Report. There's a couple of them I don't want to say if I like them or I don't like them, but those are the ones off the top of my head I can think about. I could think of. There's a few others that I saw in my perusal across the YouTube streets when this was all going down. And it made for good TV. However, there was kind of this like, it escalated. If you friends with somebody, you've been tight with somebody for a long time, and then y'all break it off for whatever reason it is, and then what ends up happening is your ex friend or your ex mentor or whatever ends up going to all of your ops that that y'all know. Like, this is nothing new. You knew these was my ops, whatever. And then it's offering to the ops, let me help elevate your channels. I'm not gonna say whether Bishop Jordan was right or that's what Bishop Jordan decided to do. I ain't got nothing to do with it. However, the result of it was then an alleged lover of Bishop Jordan, same sex, same gender, not his wife. Allegedly, this person recorded recorded a series of conversations, and somehow they made their way into the hands of Larry Reed. Now, this is all the truth. Now, I ain't got nothing else to say, but I mean, this is all the truth. Oh, what happened? This was we're going to read it. And as a result, there were some things that were brought out and were stated that the bishop said during these conversations or inferred or whatever that has now been considered to be defamation. This happened last year, back in the first call, it looks like happened in November 4th of 2025. I find it interesting that we waited until February to file this. We will talk about whether or not that was good timing or not astrologically. And we had really pretty much this had all died down. We wouldn't pay no attention to this anymore. This how it makes us pay attention. Mm-hmm. So here we go. That's where we are. That's the breakdown. And we're going to read the lawsuit to get Bishop Jordan's background, how he feels about the situation. Okay. Again, this ain't me. This is how Bishop Jordan feels about it. Okay. And this is what we got. So February 13th, we're not going to read all 36 pages, y'all. I'm going to get the highlights. But I want to be very clear. Everything I say tonight is going to come directly from either publicly filed materials in the United States District Court. Those court documents are public record. Any and I'm making this very clear because I want everybody involved to hear me clearly. Any American citizen can walk into a federal courthouse or log into their Pacer account and pull these things down. I pulled them. I read them. Also, I'm going to be citing different U.S. federal codes regarding different things, and we're going to be talking about it. And I'm going to cite the name, the numbers, and everything. So this is not. This is lay legal commentary. Okay, I'm not an attorney. I'm just someone who did the reading. I looked up the statutes, and I think I feel like you deserve more than just a hot take, and you deserve more than just a ooh girl, ooh baby. I ain't got nothing against it, okay? But a lot of the commentary I've thus far seen hasn't necessarily gone to the next level and the next step to actually research the code and not name one of them. And these happened after the order on the 20th. So nobody looked up the order on the 20th that moved the venue. At least not that I saw. They ain't talking about the moving of the venue. That's the biggest thing that we've got going right now. In fact, you know what? Let me change the title of this here video. Let me change the title midstream of this here video. Let me see if I can edit it. How do I edit the title in the middle of the video? Let me go back. Oh, here we go. I can edit. Change and change a venue. Because there ain't nobody talking about that. And y'all deserve to know about that. Okay, here we go. Y'all ready now? Because I'm ready. Okay, let me make sure what I'm seeing here. You are seeing what I'm seeing. All right, here we go. So Archbishop E. Bernard Jordan. Oh, God, I said Bernard E. Jordan. My bad. I'm sorry, Archbishop. Bishop Jordan. I apologize. I'm not trying to be funny. I am not trying to be funny. He's the plaintiff versus Larry D. Reed individually and doing business as Larry Reed Live. This is also then against Justin Edwards, Calvin R. Blake Sr., which I'm thinking is the person that recorded it. I don't mean no harm, Coach Leslie. Davon Augustus individually and doing business as Conscious TV. Marcellus McMillan individually and doing business as Mad Churches Eve. Oh, it is against Thais. Ooh, my bad. Thais Jackson individually and doing business as the Thais Report. James Singletary, Kendall Peacock, Shamarco Bryant, and John Jane Doe's 1 through 10. That's just in case he want to name anybody else. This is why I said, listen, I ain't got no dog in this fight. I'm making commentary. That's it. That's all. Okay? I'm making commentary. All right? So don't make me no darn Jane Doe. First Amendment complaint, jury trial demanded. Okay. So let's get the basis of this thing. So this is the Archbishop. He's just saying by and through his attorneys and his for and his complaint against these defendants. Here we go, listed here. The nature. This action arises from defendants orchestrated. Now, first of all, he's saying this is an orchestrated campaign of unlawful surveillance, non-consensual recording, and intentional dissemination of recordings of Archbishop Jordan, followed by the publication and monetization of false, defamatory, and highly invasive statements concerning the plaintiff's private life. Plaintiff is a nationally recognized minister with more than 4 decades of pastoral leadership, public teaching, and media presence. His credibility, moral authority, and reputation are foundational to his vocation, ministerial standing, and the trust placed in him by faith-based communities nationwide. Why is this important? This credibility, moral authority, and reputation. Basically, he's saying, this is how I make my money. He's laying down right now, this is how I'm making my money. Because I am considered credible, of a moral authority, and a good repute. Okay? Yeah, Coach Leslie, a lot of people didn't necessarily know it was this involved. We ain't scratched the surface yet. Y'all hang out with me for a little while. Y'all gonna be here for listen, I made myself a little cup of coffee. We all right. Okay. Defendants. Larry Reed, Pastor Justin Edwards. So I'm gonna have to look I don't be knowing who most of these people are. Cause I don't follow it like that. I'm over here in my spiritual world. Baby, I'm over here. Listen, we eating, we having a good time tonight, okay? Because I needed a snack. I was hungry. And Calvin Blake engaged in the deliberate non-consensual disclosure, commercialization, and amplification of plaintiffs' private sexual information across multiple digital platforms, including behind paywalls, for financial gain and notoriety. You see later on in this filing, I believe he also termed some of this as revenge porn. Now, I'm going to make a commentary right now because I think it needs to be stated. You're saying right here that there was a deliberate non-disclosure, commercialization, and amplification of plaintiff's private sexual information, private adult information. That's not saying that it's not true. That's saying you have amplified and put out here what his private sexual information was. Now, you don't know I have to say it that way for the YouTube. For the YouTube situation. I'm trying to get my hang on. Let me do this real quick. I'm just gonna turn my camera off. So that's what he's saying. Do you understand? That's interesting. Because you're not saying it, none of this happened. You're not saying I ain't do it. You're not saying it ain't true. You're saying you disseminate. Now that's what that is saying right there. We may say something different later on, but I just got to go it step by step. Okay. And I just got to call it out like I see it. Again, I don't have a dog in this fight. I'm just telling you what I see. Da, da, da. This coordinated conduct caused profound reputational destruction. Wow. Okay. Severe emotional distress and significant harm to Archbishop Jordan's ministry and professional relationships. The misconduct at issue includes, but is not limited to, unauthorized recording and public disclosure of private facts, defamation per se. I think now is a really good time to get a solid definition according to the law of defamation per se. According to the law, defamation per se refers to false, written, in other words, libel, or spoken. When it's spoken, it's slander. When it's written, it's libel. Statements so inherently damaging that they are considered inherently harmful on their face without needing proof of special damages or intrinsic evidence. In other words, you done said or written something so bad that everybody and their mama know that this is going to be bad for me. You damage me. These statements are presumed to damage a person's reputation, allowing for compensation without proof of financial loss. So why is that important that he's saying that this should be considered without proof of financial loss? Because even though we went over all of what he said, okay, we went over that. We just reviewed that, right? So even though we reviewed it, and how he makes his money is by his reputation in the church world, he's saying, I don't have to prove that I was harmed financially because it is defamation per se. Okay, so I want to say that again so we understand. By claiming defamation per se, Bishop Jordan is saying he does not have to prove specific loss, monetary earnings loss. That he don't have to do that. That because inherently and intrinsically, everything that was stated is defamatory and is damaging to my reputation and therefore my earning capability and has done major harm. Okay? So now we understand defamation per se. Civil conspiracy, they all conspired against one another. And he's saying it's civil, that it doesn't rise to the level of criminal conspiracy and revenge corn adjacent activity. So he's not saying that they actually did revenge corn. He's saying it was adjacent because of the salacious and sexual nature of what was discussed in these recordings, all carried out without the knowledge with knowledge of plaintiff's identity, standing, and vulnerability to reputational injury. So basically, they did it and they didn't give a good gosh darn if his reputation was ruined or not. Okay. Plaintiff's professional pastoral life depends on integrity, confidentiality, and sanctity of pastoral communications, and their conduct undermined those core principles. Okay, so we know who Archbishop Jordan is now. Plaintiff is a resident. This is also important. Plaintiff is a resident of the state of New York. He filed this. We're on page 3. He filed this originally in the SDNY, Southern District Court, the Southern District of New York, United States District Court for the Southern District of New York. Why is that also important? You might recognize the SDNY as where I believe Diddy was, his trial happened. Ghislaine Maxwell, his trial happened. A lot of the major trials of this nature happen in the SDNY. The SDNY is kind of notorious. It's very interesting for New York to be a very liberal city and state. The SDNY is well known, especially if you go criminally there. if the USDA, U.S. District Attorney, if the U.S. DOJ in New York, in the Southern District, decide they're going after you because you done something wrong, you done messed up, baby, you better listen. They don't lose a lot of cases in the SDNY. They are well known for their ability to win cases. Okay, so I want you to understand that it's a very powerful. That's where I believe both of the cases, the civil cases against the civil case, and then I feel like it wasn't the U.S. district; it was the state, I believe, in New York. Anyway, the Southern District of New York. That's also where a lot, and that's in the kind of area that some of the Trump stuff was done. So it's a big deal. Okay, that's a big deal. So he did it, and he said, "I'm a plaintiff, and I'm a resident of the state of New York, so I'm filing this stuff here because I'm a resident here." This is interesting. At all times relevant to this complaint, the defendant Larry Reed was and is a media personality who operates the online platform. Upon information belief, Dr. Reed resides in Georgia. At all times of the complaint, Pastor Justin D. Edwards served as senior pastor of Holy Cross Baptist Church in South in Chicago. I feel like Pastor Edwards came on and said, I ain't had nothing to do with this. Now, maybe somebody who's watching the replay later on can please help me understand that. But I feel like, I don't know if it was on Conscious TV's channel, but somebody's channel, I could have sworn they called Pastor Justin and he said he had nothing to do with this. I don't know. But y'all correct me if I'm wrong. So he's in Illinois. Calvin Blake Sr. was an individual initially hired as a driver for plaintiff in connection with a speaking engagement at a church in Houston, and thereafter maintained contact with the plaintiff. So what he's saying is Calvin Blake was his driver in Houston. So he believed he resides in Houston. Davon Augustus was and is an individual who operates the YouTube channel Conscious TV, believes that he resides in Columbia, South Carolina. I don't know if he does or not. I'm not here to dox nobody. Marcellus McMillan operates Mad Church Disease, that he's in California somewhere, but he don't know where. Thais Jackson operates the Thais Report. He's in Georgia as well. So we have Thais Report and we have Larry in Georgia. We have potentially Mad Church Disease out in California. We've got Conscious TV in South Carolina. We got Calvin Blake in Houston, Texas. We got Pastor Justin Edwards in Illinois. That's why we're on a federal level, because everybody live everywhere, and we got to figure out where we're going to try this. James Singletary appeared as a guest and made defamatory public statements regarding plaintiff that were broadcast and republished by the co-defendants. I don't know who he is. He in Georgia somewhere. Kendall, that's one of Larry's guys, who edited and altered illegally obtained audio. Oh, I wasn't prepared for that. He's saying Kendall edited and altered illegally obtained audio recordings involving plaintiff. Ooh. And then distributed such altered recordings to online bloggers and media personalities. He in Georgia, Shamarko. He was present during these playback sessions. I'm sorry. So now I'm in the room, so I'm liable for that. Okay. Obtained recording. He was present during the playback, participated in private discussions. If they was private, how you know? Furthering the conspiracy against the plaintiff. I'm sorry. Fix it. Fix it, Jesus. Fix it, Jesus. Please fix it. If these discussions was private, how you know they was private? How you know they happened? Okay. Defendants John, Jane Doe's 1 through 10 are individuals who they are presently unknown who assisted, facilitated, leaked, or republished the illegal recordings or defamatory content concerning plaintiff. Plaintiff will seek to seek leave to amend this complaint upon discovery of their identities. All right, so now we know who all the players are. Jurisdiction. Now he's saying that because he's a resident of New York, that the Southern District of New York, that district court has jurisdiction pursuant to this. Okay. By the way, let me just highlight what we're going over, right? We're going over, it's in the description. We're going to cover 4 major areas. So we're going to talk about the recorded phone calls, right? We're going to talk about the venue, the difference between exposure and defamation, and then why New Jersey, being a one-party consent state, could quietly collapse a lot of this. So he's saying that he has jurisdiction that, and because the plaintiff's claim arise under the Federal Wiretap Act and the racketeer influence. So he's basically, child, I didn't even see this. I read it, but I didn't read it. Did what this man here is saying. Let me break this down. This man here is saying basically, Rico has entered the chat. Y'all remember Rico? Rico showed his face during the Diddy trial. Rico done showed his face during the Young Thug trial. Rico done showed his face during some other civil trials. Rico, in his civil capacity, has entered the chat. So he basically saying that all these ninjas got together, and I ain't calling nobody out their name, but all these ninjas got together and decided to Rico and racketeer and conspire to put forward these defamatory, damaging audio tapes that were illegally done and illegally obtained by anybody else, and that they were actually altered. And they, in order for them to make money off of everything. Child. I told CVT that EBJ was going to play. Oh, you know what? I'm going to tell you, I honestly did not think that Bishop Jordan was going to file this kind of a lawsuit. I really didn't believe that Bishop Jordan was going to file this lawsuit. You can see I'm really unbothered. I'm going to tell you why. Because the biggest tool against defamation, a defamation lawsuit, is the truth. The biggest tool, New York gangster. What are you trying? Yeah, absolutely. The biggest tool against defamation is truth. If something you're saying, if something being said about you is proven to be true, and if it's an allegation or it's a supposition or it's, whatever. But if we're going to go through this, and I'm not making any adjudication, I'm not making any statements, but we're going to talk about wiretapping. What are the federal wiretap rules and that claim? We're going to go into the venue, and then we're going to, and the venue change. And then we're going to go through this because I'm shocked. Actually, I'm shocked. I'm shocked at the way this is worded. I'm shocked. I'm shook it. I can't believe it. I'm really surprised that we're actually putting this forward. This court, so he's basically saying Rico and wiretapping. Baby. This court has supplemental jurisdiction over plaintiff's state law claims. So basically saying this is federal because we're across all these different states. They're so related to federal claims, they form part of the same case of controversy. So he's arguing jurisdiction. Venue for this action properly lies in the Southern District of New York, pursuant to USC, blah, blah, blah. Because this is going to be critical. A substantial part of the events or omissions giving rise to plaintiff's claims occurred in this district. He is saying, Your Honor, not only am I a resident, but a substantial 50% or 40% here, 10% here, 20% there, 10% over there. The bulk of this happened, of the events or omissions giving rise to the claims happen in the Southern District of New York. Why is this a problem? Let's start talking about the calls, all right? So here's a statement of facts. You guys can read this. Maybe I'll figure out how to put this up somewhere. He's basically saying that he's never been, which to my knowledge, until now, Bishop Jordan has never, to my knowledge, and maybe some of y'all can help me out, ever been involved in any type of adult scandal. Not to my knowledge before this one. And, I know he's been around for a long time, been around for 40 years. I've never known him to be involved in one. The plaintiff and defendant Edwards had a close personal relationship. However, it did not involve coercion, compensation, or any exchange of value. Now, is that the hold on. I gotta remember the players, child. There's too many people. Oh God, you got a whole gang of people here. That's the pastor. Okay, Pastor Edwards. Jurisdiction and venue statement of facts. Okay. When it became apparent that Pastor Edwards' motivations were financial and inconsistent with plaintiff's values and boundaries, plaintiff ceased communication. So is he saying that basically, I found him to be greedy, I cut him off? At no time did plaintiff compensate Edwards for intimacy or engage in, he didn't buy it. He didn't solicit it, nor did he transact it. This is going to be good. Any financial assistance? I need to go off camera. I need to go off camera. Y'all do not need to be seeing. I don't want nobody seeing my Lord Jesus, help us all. I can't. Oh, I can't, y'all. This ain't right. He said any financial assistance plaintiff provided was charitable and pastoral in nature. Basically, Edwards, he trusted him. In furtherance of pastoral support, plaintiff provided limited financial assistance to Edwards and his spouse, including covering a vehicle payment when they lacked reliable transportation. He also retained and paid for legal counsel for Edwards' son when he became involved in a legal matter. Kudos to you for not saying what that legal matter was. These actions were undertaken philanthropically. So once he showed his true colors, he cut him off. Then here's another, right? Here you go. He worked with Reed and everybody else to retaliate and to basically try to extort him. He recorded some of these communications, disseminated them, and helped distort private life. Here you go. Reed was a former mentee of his. Reed is publicly acknowledged paying $3 million in contributions to plaintiff's ministry. Now, we know that to be true. But some of that, I think, was fees for coaching. But we'll talk about that another time. The conflict involving Reed originated in October 2024 during the election season when Reed stated publicly that Jordan supported a specific candidate. The assertion was false. A lot of us know, I think beforehand, that there was already a rift being, like, you can kind of see where things were uncomfortable between the two. I think well before the election season, to be honest with you. But fine. If you feel like that was the first significant public shift, okay, cool. Um, okay. Reed publicly acknowledged he made financial contributions and offerings during the course of the relationship. Absolutely, I watched that. Upon information and belief, Reed's relationship with plaintiff deteriorated after plaintiff declined to meet Reed's escalating financial expectations and demands, which were inconsistent with plaintiff's values, ministry practices, and fiduciary responsibilities. Now, let's all be clear. If this goes to trial, we're going to hear about it. All this going to have to come out now. That's called discovery. Following the departure, Reed made various public statements characterizing the relationship and conduct in a manner that is false and misleading. Blah blah blah. So basically, saying after he went to the White House, then Larry really put it up. Here we go. This is what we wanted to go. The illegal recording and interception of plaintiff's communication. Here we go. Now, according to this First Amendment complaint, the plaintiff is alleging that 2 separate phone calls were recorded without his knowledge or consent. On November 4th, 2025, defendant Edwards, as Pastor Edwards, initiated multiple phone communications with plaintiff. Oh, so maybe Justin Edwards is involved, who was in New Jersey at the time. Now, you all remember what I just said a few minutes ago. He alleged that basically everything downstream here happened in New York City. Do y'all remember we said that before? Do y'all remember? He said that everything, Bishop Jordan, in this complaint, said that everything happened in New York City. And that's why he needed to file in New York City. However, here we go. First inconsistency in a filing. And if there's anything judges can't stand, I've seen where basically you'd be like, oh, there's all this misspelling and bad punctuation and all kinds of stuff. Judges will suffer all that BS. What they won't suffer is you saying that I'm going to end this affidavit in this signed document that is it considered evidence? No, not really. But in your pleadings, you say, I'm going to, all this X, Y, and Z happen. And then we find out later on, it was really A, B, and C. Well, where the X, Y, and Z? So you state at the very beginning of all this, the reason for jurisdiction and the reason why the USDNY has jurisdiction is because everything happened in New York. Well, right here off the rip, we already, that ain't happening, baby. You said communications happened with you and you was in Jersey. Defendant Edwards was physically located in Illinois. Now that is interesting too. I think Illinois is a 2-party state. Let me look. Is Illinois? Ooh, why I can't spell a 1-party consent state? Let's see. No, Illinois is a 2-party or quote unquote all-party consent state. That's under the Illinois State Compiled Statute 720 ILCS 5/14-2. It is illegal to record or eavesdrop on a private conversation, whether in person or via phone, without the consent of all parties involved. Now, that's going to be very interesting. That's going to be, okay, now we cook it with gas. This is interesting, y'all. Okay, here we go. At approximately 3:58 p.m. on November 4th, 2025, defendant Edwards called the plaintiff. The conversation lasted 1 hour and 2 minutes. During the call, Edwards transmitted to plaintiff a photograph of himself with defendant Reed, a reference to a quote-unquote story allegedly being prepared about plaintiff while denying any involvement. The conversation quickly turned to confrontational and hostile, and plaintiff communicated that the relationship was ending due to Edwards' conduct and inappropriate language. Later that evening at approximately 9:55 p.m., I wish they put Eastern or what time zone, on November 4th, defendant Edwards attempted another brief call lasting 18 seconds. At 9:56, Edwards initiated another call with plaintiff lasting 45 minutes. This call constitutes the central event giving rise to civil and criminal liability. Now, this is the first time he's saying criminal. It's the first time he's saying criminal. He's probably bringing the civil suit to see if he can get enough to file criminally, because if he had enough criminally, I believe he would have filed it. Or he wants to get the money first, and before he ever, a lot of times, this is what's done a lot of times. We file civil and then we see if we can get criminal. And a lot of times the DA or whatever, the prosecutor's office will be like, maybe I ain't got enough. We ain't got enough here, so you're gonna have to go civilly where it's a preponderance of the evidence, or there's another more likely than not, or whatever. It's 51% basically. Okay. During the 9:56 p.m. call, defendant Edwards merged defendant Reed onto the call without disclosing Reed's presence and without obtaining plaintiff's consent. For the entirety of the call, plaintiff was unaware that Reed was present or recording the conversation. So now we enter into the chat, enter into the call, Larry Reed. We don't know for sure. This is a little commentary here, y'all. We don't know for sure where Pastor Edwards was. He thinks he was in Chicago. Remember up here, he said, I think. He says defendant Edwards was physically located in Illinois. I don't know how we know that for sure. Now, you may be able to then triangulate and figure out where his phone was at that time with the phone records. That would probably be the only thing that will tell us where he was physically. Now, here we go. Let's go back down here. Defendant Reed has since admitted he was located in Dubai at the time that he was merged onto the call with defendant Edwards, and that he recorded without plaintiff's knowledge or consent. Now, I don't know if can I have one party consent to record a call in Dubai? Let's see. And in Dubai, you cannot use one party consent to record under UAE law. So their laws, United Emirates, specifically federal decree law number 34 of 2021 on combating rumors and cybercrimes, recording, eavesdropping, or sharing private conversations, including phone calls without the explicit prior consent of all parties, is illegal. So if this is the case and he recorded it, he is the one that recorded it without Jordan's consent. Yes, it happened in international waters, but if this is all true, now this is very important. If this is all true, potentially then, we're looking at two people being somewhere where it is not legal to record a call unless everybody knows. Well, I understand that. The recorded call was allegedly, we getting to that point. We ain't got there yet. We ain't got there yet. We getting there. We getting there. We getting there. Hold on. We getting there. All right, let's keep going. I'm going over this specifically though for some reasons. Because we're going to talk about these calls, their location. Because remember, at the in the pleadings, he's already said, "Hey, it all happened in New York, it specifically within the Southern District." Well, already we can tell it didn't. So SDNY now, New York definitely is a two-party. It's an all-party consent state, definitely, which is why you would want it there, right? New Jersey isn't. Georgia isn't. Texas isn't. Okay, here we go. Reed admitted recording the call. What? Reed admitted he recorded the plaintiff's conversation with Edwards. In a public broadcast dated October 15th, prior to the November 4th call, Reed stated the following. This is interesting. There's someone else that has come to me by night. They were not coming to me to be messy. I'm sure that's messy, not messing. This is after their breakup. But because they were lied to, they thought they could come to me about their truth and the truth of my former mentor. I recorded every conversation and told them I recorded that every conversation. Y'all, come on. Oh my God. Did y'all? Am I missing something here? So he's saying that on October 15th, Larry Reed admitted to recording a call in the future. That's what he's trying to say, that he's trying to tell the court that. Okay. I just wanted to be sure we all understood that. All right. In Reed's private members only broadcast, he's made even more explicit admissions about the existence and use of these recordings and admitted using these recordings to support his public accusations. It's on audio. It's on audio. I can tell my truth about what I was told by Justin. So we don't know. We don't know if these recorded phone, is he referring to the recorded calls between him and Justin that he told Justin he's recording? Is he referring to, because this is October 15th. This is prior to the November 4th call. It's problematic. But the audio verifies what I'm saying. So he's saying that because he made these public admissions, it demonstrates that the November 4th recording was not accidental or isolated, but part of a broader pattern of intentional recording. I don't think that's gonna go. Because if I'm a jury and I hear that, that's my first thing. Like, so you future snitching? Like you saying in the future that are we back to the future now? Are you time traveling? Just because he said he recorded these calls, and we don't even know what calls he was talking about. That could have been just between him and Justin, or it didn't even have to be between him and Justin. It could have been between him and somebody else. We don't even know. Come on now. All right. He basically hears Sam. I didn't think it was going to happen like that. Okay, here we go. The independent illegal recording by defendant Blake. Let me go over here. Look at my notes. The second call, which was allegedly recorded without consent, that defendant was in Texas. And he was in Jersey. So, defendant Blake sent an email to defendant Reed referencing the recorded communications on November 26th. I've been helping a friend. Oh, Oh my. In this email, Blake stated, I have been helping a friend whom he prepared and violated many times all the way until recent as weeks ago. The last convo they had was out the blue, and I was with my friend, and I recorded the entire exchange. Thereafter, plaintiff became aware that defendant Blake recorded a private telephone conversation involving plaintiff without his knowledge or consent. He ain't saying that it didn't happen. On December the 26th, Conscious TV confirmed the existence of said recording and said, because there's a lot of people who got audios. Larry, Bishop Blake, all of them got some audios. The plaintiff was physically located in Jersey at the time of this conversation. We're going to go into what was in here, but he's already saying that there was actual misconduct, basically. That's what violated means, actual misconduct. Now, this one is important because both New Jersey and Texas are one-party consent. So if defendant Blake was in, this is my opinion, my non-lawyer layperson opinion. If defendant Blake was in Texas and the plaintiff was in Jersey, those are both one-party consent. If Blake is with the one party in Texas that is having the conversation, and he gets permission from that one party in Texas to record the conversation, there's one party that knows the conversation is being recorded, and both parties are in one party consent. Now, Bishop Jordan is saying that under the Federal Wiretap Act, specifically 18 U.S.C. 2511, he's saying that under that act, that's why this was illegal. Here's a piece that most people glossed over. Under federal law, it is not automatically illegal to record a phone call just because the other party didn't consent. The recording becomes a federal crime when it is done for the purpose of committing any criminal or torturous act. That language is right in there. 2511 section 2, paragraph D. Now that's very important for both of these. It's not automatically, because remember, let's also come back. We'll come back to what this is in a minute. But I'm getting on this because I think that this is a distinction that most people are missing when we're talking about the validity of this filing, or whether or not we think the filing has merits and where is it going to go. And I'm not making any legal decisions. I'm just saying, and I need to keep saying that because this is my opinion. Again, I ain't got a dog in this fight at all. But I'm looking at it objectively. Objectively, according to the federal act, the Federal Wiretap Act, 18 U.S.C. 2511, even if on a state level it is not a one party, even if on a state level it's not one party. So Illinois is two party, where the pastor was, and in the first call, November 4th, and Dubai is a different country, but it's two party, but New Jersey is one party. It is not automatically illegal to record a phone call on a federal level just because the other party didn't consent. The recording becomes a federal crime when it's done for the purpose of committing any criminal or torturous act. That means that he has to then prove, that's why he brought the RICO in there. He has to prove that somehow this was done as a torturous act, as something criminal or torturous, extortion to make money off of him, He has to, there has to be something there. And if he's able to do defamation per se, then it's a result of that. I think that's a stretch, in my opinion. In my opinion, you're then saying that they all conspired before November 4th. They all got together and they all said, hey, we're all going to make money off of this. We're going to get Bishop Bernard Jordan. When, and y'all could tell me if I'm wrong, when I believe for sure Conscious TV and Larry Reed, they might not have been in a bad place, but they certainly weren't in the same place they had been for years. You know, they've been had a falling out. They've been had a falling out. It wasn't the same thing. So you can't even say that they was really conspiring or they weren't even talking to each other as nearly to the level that they had been over the course of years. And I'm not telling a tale out of school. That's well documented. I don't believe that Thais nor Mad Church Disease, I don't think either one of them really had no relationship with either Conscious or with Larry Reed, to be honest with you. I mean, y'all correct me if I'm wrong. I'm not necessarily in that church sector, but baby, I don't think that these aren't even what we could call strange bedfellows. These are people that weren't communicating with one another. And let us also not what's going to come back to what could potentially come back to bite Bishop Jordan is prior to all of this? Like these recordings and stuff coming out. He was on Thais. He was on Mad Church Disease. He was on their channels, dogging Larry out, dogging him out. Cause I watched it. He was on there basically telling them, well, I'm gonna invite y'all to come to Florida. Had an event where he was by invitation only. I don't remember if they had to pay. I didn't know. I wasn't invited. I don't care. Anyway, he was on there. He was steady talking about his mentorship and the $30,000 and get it, and then he was going to have them all there to talk about AI and how it could help their channels and all this other stuff. And I'm sitting there going, y'all need to call me if y'all want to know about some AI, because I'm the AI person. Like, what y'all doing? But anyway, that's beside the point. Anyway, so he on there trying to basically rally the troops. Because remember, he was doing the tour de ops. That's what I like to call it, the tour de ops. He was doing the Larry tour de ops, or tour de Larry's ops. He was basically, to me, this is what it felt like to me, outside looking in. To me, it felt like, Jordan and Larry had really been an inseparable, very unstoppable team. And it really elevated a lot, right? It just like they were very inseparable. And a lot of these people were talking about that they were engaging in, or especially Bishop Jordan, pay for prophecy, prophetic. You pay, you get a prophetic word. I don't necessarily agree with that, but I'm just saying that that's what they were saying. So now these two, the dynamic duo has split up. Batman and Robin, whichever one you want to call it, have split up. Okay, the Avengers, Iron Man and Thor, whatever it is, they're split up. So now the one now goes because, whatever. I mean, I'm sure it's a hurtful situation, but now they're basically kind of going around and he's kind of like basically saying, hey, the magic that I helped Larry with, I'm going to help you with. He's kind of like Bill Belichick to Tom Brady. He basically is saying, I made Brady who he is, so I'm going to go around here and see if I can't make another one. That's my opinion. That's my opinion. That's how I looked at it from when I saw it. Now, y'all can think what y'all want to, but that's my opinion. That's how it looked like from the outside looking in. And I've been around for a while. You know what I'm saying? I was born at night, but definitely not last night. Okay, let's get back to this. So my point is that it's a meaningful distinction. Now, the Second Circuit addresses this directly in Cairo versus Weintraub, 618F 3D 94 in 2010, where the court confirmed that the purpose behind the recording, not just the act of recording, is what determines liability under the federal statute. So the legal question isn't just was the call recorded? The question is, was it recorded for the purpose of defaming someone, extorting someone, or committing some other tort or act that could be sued for? That's the standard that the plaintiff has to prove. And the plaintiff does allege exactly that. He alleges the recordings were made specifically to damage the plaintiff's reputation and to monetize that damage through subscription platforms and paywalled content, and to use the recordings as leverage. Those allegations, if proven, would satisfy the purpose element. But, and this is the part that I really want you to see, but allegations in a complaint are not evidence. They are what the plaintiff claims happened. The defendants haven't answered yet. The discovery process hasn't begun, and we're at the very beginning. So he has to prove, let's see what else he says. He'd have to prove that they did this for this nefarious reasons. So here we go. Let me go back over here. Okay. Defendant Blake was physically in Houston. Okay. Plaintiff did not consent, nor expressly nor implied to the recording, interception, preservation, blah, blah, blah. Blake's written admission that he recorded the entire exchange with plaintiff demonstrates that a recording was intentional, knowing, and undertaken. Okay, we know that. Thereafter, Reed forwarded Blake's email and its contents to third parties, including... Well, William McCrae is not in here. Oh, now you talking about defend. William McCrae is not a defendant. Did I miss that? Thais is. I don't think he sued William McCrae. This is interesting. Maybe he meant to. Intentionally distributing information derived from unlawfully recorded private communications. Now, as a part of a broader effort to collect, circulate, and exploit plaintiff's private conversations. Y'all, this is going to be interesting. I don't know if it rises to defamation. However, what other reason other than the reason to discredit this individual could there have been in releasing, not recording, but the releasing? And perhaps they were recording to get evidence to be able to prove later on. Maybe these people were going to put out some sort of civil or criminal complaints. I don't know. The coordinated defamation beginning on or about December 20 or 25. So a month later, defendants started releasing emails, audios, and private conversations. On December 6th, Conscious TV published this title, Larry Reed, The Cover-Up, Bishop Bernard Jordan Exposed, Emails and Audio Shocking. Okay, here we go. Now he's saying that these are defamatory statements made claiming that the plaintiff was engaged in extramarital affairs, speculating about his sexual orientation, and allegations of tax evasion. Ooh, and stalking. I didn't see all that. Ooh, baby. I didn't see all of that. At approximately 1 hour and 27 minutes, multiple audios exist of Bishop Bernard Jordan exposing his extramarital affairs with a man. 1:28, we have audio proof of Bishop Jordan's affair with his male lover. Ooh, the male mistress called the wife. Ooh. He said the male mistress called his wife. Oh my God, today. Okay, hold on. Graphic descriptions of adult acts performed by plaintiff, including vulgar references to positions and acts. Oh, Bishop owed the IRS $400,000. Bernard is distressed about money. We learned from this audio. He is gang stalking the person, calling church members, harassing them, manic, obsessive, and weird behavior. And these other false statements of violations. Bishop has been queer his whole time. It goes back 40 years. Ask Isaac Jordan. Now this is rough. Defendant Singletary, allegations of violation attributed to defendant Singletary read out loud. This was known by ex-Zoe members. His nephew was, oh my gosh, by his personal assistant. Wow. This is serious. I didn't know all this. So there was numerous. So this whole thing, that's the constitutes the defamation per se. Wow. According to CTV, I don't know nothing about the defendant Singletary. I don't know. I do know that CTV said everything that he stated in here was a repeat of what was stated in the audio. If it's the truth and he made the statements in the audio, then it can't be defamation per se. You would have to say it was defamation per se if it was untrue. Like if he never said anything, if he never stated he was having an affair with the man, if he never stated that the male mistress called the wife, if he never stated that, different acts and different this, I like it like this, I like it like that. If it's not true that he ever owed the IRS $400,000, I don't know. Now that's not necessarily tax evasion. You owe the IRS $400,000. You trust me, if you had tried tax evasion, they'd have got you. So that's not tax evasion. That's saying you owe the IRS $400,000. Those are two very different things. Like, whatever. So I don't know if there's proof in these emails and or in these audios that he actually did like orchestrate something. This I'm a little more concerned about. Now, in the church world, those of you who are in the church world, especially those of us who have had interactions with pretty major or even not major clergy, people in the ministry. Listen, there's rumors that always abound. And I'm not saying that Bishop Jordan was or was not queer or is not queer. I don't know. I don't know what's going on in that man's bedroom. But there's always rumors that abound. Historically in the Black church, we just don't act on them. There's always the whispers. But historically, unfortunately, we don't act on them and we let it happen. We blame the victim. So I don't know if this is true or it's not true, but this is serious. So I don't know where that's coming from. Broadcasts contain numerous false statements, implications, defamatory statements. Defendants and collaborators made graphic, salacious, and sensationalized statements. Defendant James Singletary further made defamatory statements accusing plaintiff of abuse, targeting young boys, claiming that the ministry was fraudulent, corrupt, and demonic, and that plaintiff is bipolar, mentally erratic, and unstable. My God, today, that's a lot to say. That's a lot. That's heavy. Like that. But now here you go with the free speech. Did Mr. Singletary say that it was his opinion that is fraudulent, corrupt, and demonic? Did he say that it was his opinion that he is bipolar, mentally erratic, or unstable? Because if that's his opinion, is that defamation? Is anybody taking that for fact? I don't take it for fact. I'm hearing it. I don't know. I I'd be more concerned about, I'm not even concerned about the tax debt. I'd be more concerned about some of the other allegations than, I don't know. Definitely this essay and targeting young boys. That's I really uh, oof. Okay, mad church disease published multiple videos discussing plaintiff in a defamatory manner, dated the 17th, the 1st of December 1st and December 2nd, which amplify harmful narratives derived from illegally. Well, no, you cannot say that the 17th of 2025 was derived from harmful narratives derived from illegally obtained recordings when the illegally obtained recordings, according to you, didn't happen till November. Again, your future, he's allowed to have any type of opinion about you and your ministry. That's what he does. And you had been on his channel multiple times prior to this, or maybe you appeared right after the 17th. I'll have to look. Let me see. You know what? We going to I wonder if he took it down. Let me look up Mad Church Disease and see when he was on here. Because if I'm Mad Church Disease, I ain't doing it. I ain't taking it out. Mad Church Disease. Here we go. Let me look here. Lives. December. I'm going back. So 4 months ago, 4 months ago, let me see, when was Jordan on here? Larry Reed threatens to tell all. When was he on his channel? Did he take it down? I feel like it was about 4 months ago. So this is February, right? So January, December, in October is when he had him on his channel. He may have taken those down, but he needs to bring him back up because that's gonna help him defend himself because he had him on, and I clearly remember watching those broadcasts, and it was like, I've not said very nice things about you, and basically it was all cool and copacetic. He needs to put them back up. Among the most egregious statements on the mad church disease was that basically he's repeating what everybody else was saying. So now, at what point does the repetition of what somebody else has said become defamatory and it not be media? This is one thing I want to bring up. I think us as YouTubers and anybody that engages in commentary is going to have to start with the media, right? We're going to have to start with stating that we are part of media. We're going to have to start conducting ourselves in that manner. Okay. Hey, Purple Couch. Yep, we already reviewed all of that before, that New York and New Jersey are not two-party consent states. We already reviewed that before. New York is a two-party consent. If I remember correctly, let me look that again. But I could have sworn. Oh, New York is one party as well. Well, then he screwed up. When everyone gets deposed, the truth will come out. Yeah, we know. I think that he's hurting himself a lot because if there's anything that's stated in here, which I do know, let's just be real. Both Larry Reed and CTV and a number of other people, YouTubers, we learned from Tasha K. We learned what not to do, right? We also learned that just saying allegedly doesn't always necessarily help you. You have to conduct yourself as a media person. You don't have to have a journalism degree in order to be considered media, in order to be part of media. That's not how this country started. This country didn't start with you had to have a journalism degree from a college in order to be a writer or be the media. So we have a First Amendment right to speak, to have opinions, and things like that. We don't have a First Amendment right to harm someone. We don't have a First Amendment right to falsely accuse. We don't have a First Amendment right to cause harm or defamation or any other kind of torturous act. Tortuous act. Now, if you've seen Mad Church Disease at all, he always talked bad about Larry, and he always talked bad about, eh, that ain't nothing new. So if his opinion is your trash, that's his opinion. But you went on his channel after the breakup and was on his channel a lot, lived over there on that channel for a hot second, and then brought your son over there. I seen it. Mad Church Disease, you need to put that back up because that needs that. Listen, he was there. Let's not play. Let's not play it. Okay, repeat of the audio and a few was repeating what McCrae said that he had that preference, but Jordan did tell another person he owed, and that's fine. Like him owing the $400,000 to the IRS is not tax evasion. See, you're being a little hyperbolic when you put in a pleading that you're submitting to the court that that they said that was committing tax evasion. Maybe they did say that, but at the end of the damn day, who cares? Like that to me ain't the biggest of all things. And if you said you owe $400,000, then you owe it the $400,000. And man, come on. I don't know. I got problems with this. One person. You cannot place a recording device in a room. Okay. Where was I at? He still is going to have to prove that the purpose behind the recording was not just to act, right? That it was the reason behind it. Okay. I'm gonna let's see. Reviewed hundreds of times, thousands of times collectively. All these people were all in a conspiracy with each other. This is gonna be. He gonna have to have somebody gonna have to have snitched in order to prove there was a RICO. Cause that means everybody was in on the same thing at the same time to commit conspiracy. Rather than if I'm CTV, I'm like, nah, it's just breaking a story. I don't like him like that anyway. It's been well documented. We ain't rolling like that. Like that used to be my man's, like that used to be my dude. I used to F with him, but I don't F with him like that anymore because he went over there and let McCrae talk bad about me and call me all out my name and say nasty things. Yeah, I be knowing, but I just be in the bushes. I be knowing what be going on the streets. I just don't commentate. I don't have commentary on it a lot because I have other things I'm doing. But my point to the matter is, this is real easy for CTV. What? I don't talk to him like that. Mad Church and the Thais report. I don't know what he's talking about because we had him on my channel and those we did good numbers and this, that, and the other. I don't rock with Larry like that. I don't rock with CTV like that. That ain't how it go. We don't talk like that. It's gonna be too easy and well documented. Um, Defendants knew our reckless disregard, cross promotion, repetition, and nobody cross promoted nothing to nobody. Nobody cross promoted nothing to nobody. Okay, I want to go over something else. Let me go over something else. Can I please? Okay. we're going to go over this document. Now, mind you, remember the amended complaint was filed on the 13th of February. On the 17th of February, this is something I don't know why ain't nobody talking about. And Perp, you've been around. Is anybody talking about the fact that the venue got moved? I don't know if you've seen it anywhere else on the streets. Can you let me know? Let me go back over here. Here we go. On the 17th, this is straight from the judge. This is an order, not just somebody. This is an order from the judge. On the 17th, here you go. Margaret M. Garnett, United States District Judge. In this lawsuit, plaintiff alleges that several defendants recorded 2 phone calls with plaintiff without plaintiff's consent. Plaintiff also alleges that these and other defendants made highly defamatory statements about him in public forums. Although these are serious allegations, none, N-O-N-E, none, involve this district or the state of New York. And the court, therefore, cannot ascertain why venue is proper in this district. Section 1391 provides that a civil action may be brought in 1. A judicial district in which any defendant resides, if all defendants are resident of the state in which the district is located. 2. A judicial district in which a substantial part of the evidence or omissions giving rise to the claim occurred, or a substantial part of the property that is the subject of the action is situated, or 3, if there is no district in which any action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. 28 U.S.C. 1391, paragraph B. Plaintiff does not allege that any defendant resides in the state of New York. That's why I went over that very carefully earlier. Moreover, none of the, quote, events or omissions giving rise to the claim, end quote, seemingly occurred in New York. During the first recorded call on November 4th, 2025, plaintiff was in New Jersey. Defendant Edwards was in Illinois, and defendant Reed was in the United Arab Emirates. See docket number 5360, also 58. Those are the points, right? Describing the November 4th, 2025 call as the central event giving rise to civil and criminal liability. So he says that this November 4th phone call was the central event giving rise to civil and criminal liability. And then, but it didn't happen. Nobody was in New York. During the second recorded call, plaintiff was again in New Jersey and defendant Blake was in Texas. See identifiers 68 through 71. Besides the recorded phone calls, plaintiff alleges that multiple defendants made multiple defamatory comments about him, but no defendant resides in the state of New York or seemingly made any defamatory comments about the plaintiff within the state of New York, let alone inside this district. So she says, see the points 11 and 77. Alleging that defendant Augustus, who resides in South Carolina, published a video defaming plaintiff. Because it does not appear that venue is proper in this district, it is hereby ordered that on or before February 20th of 2026, plaintiff file a motion to transfer this action to another district or a letter explaining why venue is proper in this district. If plaintiff opts to file a letter, the letter should also specify a district in which plaintiff believes venue would be proper besides the Southern District of New York. If the court does not receive the court-ordered filing by February 20th, it will sua sponte transfer this case. Okay, so that was that. Now, nobody talked about that. Let me look and see if anybody talked about that. Again, if anybody has seen anybody talk about this before, please let me know, because I'm gonna cut this out and I'm gonna clip this. I'm gonna put this up because this is important. We're missing the whole point. So what happened then? On the 19th, they filed a letter. Okay, here's the 19th. Here they are, February 19th, electronic filing. Da da da. Dear Judge Garnett, plaintiff, blah 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 blah. Okay, here we go. Legal standard. Under Section 1391B2, venue is proper in the judicial district where a substantial part of the evidence, events, or omissions giving rise to the claim occurred, or a substantial part of the property that is situated. The fact that plaintiff suffers harm in a particular judicial district is sufficient to satisfy that. Oh, Jesus, Mary and Joseph. Okay, see Kirk v. New York State Department of Education. See also Bates v. C&S Adjusters, concluding that a plaintiff's receipt of a collection notice is a substantial part of the events giving rise. What? Child, So he's saying basically, because I live here, that's good enough. And because he's suffering harm in a particular judicial district, that's sufficient. No, it's not. Because you introduced yourself as a national and a global minister with widespread, far reach. I'm paraphrasing. So that's how you put yourself out here. So you can't now say, well, I live here, so this is where most of my stuff be happening. No, you already said you was global. The Second Circuit has emphasized that when a court examines the question of whether or not venue is in a form is proper, it must focus on where the defendant's acts or omissions occurred. Okay, but you said yourself they occurred in different states. None of them happened in New York. The courts have clarified this does not require the district to be the location of the most substantial events, but rather the significant events or omissions material to the claim occurred there. Whatever. This is the thing. This is the thing. I don't mean to be talking loud, but this is the thing. When a judge tells you, look, Ninja, I don't find that most of this stuff substantially happened here. The defendants were here by your own admission. You're going to have to give me a better reason. You don't come back and say, well, Judge, but they were there. Ninja, you just said they wasn't. Come on, man. Okay, here we go. Okay. Venue is proper in the Southern District of New York under 28 USC 1391B2. Blah, 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 blah. The complaint alleges substantial reputational injury and damage to plaintiff Archbishop Jordan's professional standing as a minister, as well as injury to the operations and membership of his church. So they're saying people that left the church. His church is in New York. This is where I've had the most hit. While the Archbishop is a nationally recognized minister with trust placed in him by faith-based communities nationwide, the church's congregation, ministry activities, and community presences occur within the district. So you never go out of New York and do nothing? Okay. Plaintiff's church is located within the district, and the harm to his congregation and reputation fell within this district. I would venture to say it was actually nationwide because, baby, and globally, because, baby, them broadcasts was everywhere. Okay. The reputational economic injury occurred in this district. Again, they're basically more of the same. They cite a couple different things, different cases. The venue was proper in Utah. A plaintiff resided despite the fact the defense was located in California because the plaintiff had telephone conversations and corresponded with each of the defendants from Utah. Listen, you said here, okay. They are saying they are using cases that basically bolster the judge's point of view and go directly opposed to their own. You cite a case where the venue was held in Utah to be proper where the plaintiff resided, despite the fact the defendants were located in California, because plaintiff had the telephone conversations and corresponded with each of the defendants from Utah. At no point did you say in your pleadings that Bishop Bernard Jordan conversated with any of these people, conversed with any of these people via telephone which is your main basis for this whole thing, right? Nay on time did you say that he was in New York when he took any of these calls? Okay. All right, cool. The alleged misconduct is results in a significant and measurable harm within the district, including financial and ministerial losses. You know what? My opinion. Had they leaned into that more, they may have had a fighting chance. But you basically, this is my opinion, you basically cite cases that support what the judge has already said. The reason why she's like, yeah, I'm finna kick this. You just supported her for everything. If you had leaned into this, ministerial operations are primarily located within the district. You serve congregants there, and probably given, I think, even though you're doing defamation per se, for me, I would have from October of 2024 shown congregants, attendance, offerings. I would have shown some finances and some demographics to prove that you lost congregants significantly after this November situation, that you lost, that your donations went way down. Now, I don't know if you can separate that out. Like, you'd have to separate it out from the church donations, from the donations that you were getting via Super Chat, PayPal, Venmo, whatever, because you were on Larry Reed Live's platform. That's significant. And you can't say that was because of defamation, because you all had already split ways. I think we might be on to something here. Like he used to make quite a bit. If I remember correctly, there was quite a bit of donations and stuff that, offerings or whatever the case may be, that was given to him during that time period. But anyway, he would have had to show that there was a significant drop off in New York City from his church and everything like that. To me, you lean into that, then you maybe can make the argument that the injury, everything else may have occurred outside of New York City, but the injury happened, like you felt it in New York City because your business is there, your church is there, okay? Although plaintiff also maintains residence in New Jersey and was located there doing 2 phone calls a day, the locus of this injury is within now. So they basically saying, Judge, keep it here because basically, listen, this is where I've been the most injured. Okay. All right, here we go. Okay, the venue fight. Okay, so the judge, I read her order that she issued on the 17th, raising the venue question on her own. Nobody else had to raise it. She's the one that said it was a fight. She's the one who said, I don't think this belongs here. And when you do a sua sponte transfer, meaning the court acts on its own motion without waiting for either party to ask, okay? And that authority comes from 28 USC 1404, paragraph A. So the venue in federal court is governed by 1391B. And we talked about how they can establish it. But then the response letter basically says that the church is in New York, and they cited some, reasoning behind it, but they really just supported what the judge was saying. So the judge was not persuaded. So let me show you what the judge said on the 20th. And this is going to have significant ramifications in this case. I don't care what anybody says. This will have significant ramifications. The judge read that letter and was like, yeah, pimp, I don't think so. On the 20th, so on Friday, plaintiff commenced this lawsuit in the Southern District of New York on February 10th of 2026. He alleges the defendants illicitly recorded 2 of his phone calls and made defamatory comments about him because no defendant resides in the state of New York, and the acts or omissions given rise to the lawsuit occurred outside of the district. The court ordered the defendant to either move to change venue or explain why venue is proper. I think that she meant the plaintiff because that's what she said. On February 19th, the plaintiff submitted a letter arguing venue is proper because plaintiff is experiencing harm from defendant's defamatory comments in his district where he resides. Plaintiff also submits that in the alternative, venue be proper in the District of New Jersey. I didn't see that, but maybe they said it in the conclusion. The plaintiff's letter fails to show venue is proper in this district. As plaintiff concedes, a court examining the question of whether venue is proper must focus on whether the defendant's acts or omissions occurred, on where they did. None of the defendant's acts or omissions occurred within the Southern District of New York. No one who participated in the first or second phone call was in New York. Defendants are alleged to have recorded the calls outside of New York, and no defendant has made defamatory comments about plaintiff inside the state of New York. Accordingly, for the reasons explained on the earlier order, it is ordered that this case be transferred to the U.S. District Court for the District of New Jersey sua sponte. So basically, I'm kicking it to New Jersey. The judge was not moved. And I got to think it's because of all the things that we said. I'm sorry, that was really small for y'all. Let me make it bigger while I'm having the conversation here. And let me go over here. And this is really the meat and the potatoes. This is basically the whole thing. So basically, she's saying the conduct didn't happen here. None happened here. But what this is not is transferring is not saying, hey, I don't think it's valid. It's just saying it don't belong here. So it's procedural. The case is going to be there in New Jersey. It lives on, but where it is litigated matters. Different jury pools, different local rules, different judicial culture. So this is where it's going to get very interesting. New Jersey is a one-party consent state when it comes to recording calls. Okay, as long as one person on the call consents, that person can be the one doing the recording. So remember I was saying, the person recording was in a two-party state, or the person recording was in a two-party country. One-party consent, either party can be the one doing the recording. Under New Jersey state law, which I know you're saying this is federal, but in these cases, like the Cardi B Tasha K case, yes, it was a federal case, civil defamation case, but it was going also according to Georgia state law. It's a really weird, civilly, it's a very interesting interwoven thing that happens with the federal cases where they're tried. That's why it's very important, the venue, especially in civil cases. Even if you look at the Johnny Depp versus Amber Heard case, there were certain rules in Virginia that applied that would not have applied in, let's say, California. So Johnny Depp brought it in Virginia. I don't know how he managed to get venue there, but he did. And I'm sure that actually ended up being instrumental in him, or was a serious help to him getting that and him winning his case. I think he should have anyway, but it's a serious help. So the New Jersey laws are going to play a big part in this. The plaintiff was in New Jersey during both calls. That matters because if the recording is evaluated under New Jersey law and one party to the call consented, the state law wiretap claim may simply not hold. So all that wiretapping stuff, it might go. Now, does it federally still apply? Yes, or could it? The federal wiretap operates independently of state consent laws, but the nuance here is if federal courts, when applying 2511 to Section 2, Paragraph D, have recognized that a recording that is otherwise lawful under state law weakens the argument that it was made for the purpose of committing a tort. So if it's available under state law, if you can do it under the state, the federal law, the federal courts then tend to give the nod to the state. Like it says, well, it's legally. So now you're really going to have to prove that it was criminal in nature. That's going to be a real evidentiary and framing challenge for the plaintiff. Now, Illinois is a two-party consent state, so there is a genuine conflict of the law issue here. Which state's law applies when the parties are in different states? Federal courts have generally applied what's called the most significant relationship test. And there's a restatement, second of conflict laws 145, that guides that analysis. So the outcome is going to depend on where the most significant contacts are centered. That's going to be the real legal fight there in New Jersey. What it really means is for that wiretap claim, which is one of the central tenets of this whole thing, it's going to be quite complicated in New Jersey because the plaintiff, Bernard Jordan, is going to have to then be able to establish the interstate nature of this and the purpose element under federal law. That's a lot. And the wiretap claim weakens or fails on. So if there's a summary judgment that these were not illegally obtained, and in other words, violated the wiretap rules, laws, statutes, clauses, then the entire case is going to shift solely to defamation, which could be significantly harder. Okay. Let me see. How much further do we have to go here? Let me go back to here. So we reviewed the fact that that in the amended complaint, it was alleged he did a lot of lewd and lascivious, let's just say, acts. Sustained and will continue to stain. So I'm going to put this down. I'm not going to go through the whole thing right now because it's a lot. So basically what he's saying here is they violated wiretap because they did this for the purpose of committing a criminal or torturous act. Is it? Or did they record it because they wanted to get proof of what they were saying out of your own mouth to validate claims? That's not criminal, nor is it tortuous. Okay, we know where they were. Violate. Here's the RICO part. This is kind of what I. So 1692C of the 18 U.S.C. makes it unlawful for any person employed by or associated with any enterprise engaged in or the activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises affairs through a pattern of racketeering. So there's conduct of an enterprise through a pattern of racketeering activity. This is a real loose enterprise. These people don't F with each other. Plaintiff must show at least two predicate acts. So let's see, this is going to be interesting. The RICO damages, plaintiff need only allege that it suffered injury directly resulting from one or some of the blah, blah, blah. The enterprise consisted of a coordinated group of defendants acting in concert. That's not going to fly. Because everybody is making their own money on their own channel. Nobody cross-pollinated. So Reed, Edwards, and Blake associated together for the common purpose of engaging in a course of conduct. So he's basically saying that Larry is the kingpin and just organized everybody to do everything else. The enterprise engaged in affected interstate and foreign commerce through the use of telephone communications across state lines and internationally. What? How is that commerce? They didn't make any money on the phone calls. And dissemination of content via internet platforms accessible nationwide and internationally. Who got paid? Okay. Racketeering activity, blah, blah. What's the predicate acts? Okay. This is where the RICO could fall apart. Could. You're in New Jersey now. If you lose the wiretap, you lose the predicate act. So he's saying that there was wire fraud through the use of interstate wire communications to further a defamatory scheme and conspiracy of recording, So you basically have to say that there was a concerted effort to record all of this stuff, and then they knew that they were going to disseminate it and put it out on the internet. And they knew they were going to make money. Well, you don't always have to make money. Did he prove that? On November 4th, they used interstate wire communications to unlawfully record the plaintiff's conversations with Edwards discussing their. Whoa. Plaintiff's private conversation with Edwards, where they discussed their private consensual relationship. Now, is that the private platonic relationship we talked about before? Or is there another private consensual relationship we need to be discussing? It's 11:11. This is problematic. This is problematic. What does that mean? What does their private consensual relationship mean? Because the inference in that consensual, I consented, and it's usually said in regard to an adult intimate relationship. Oh, this is problematic. Yeah, we know Larry was there. Da 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 da. Plaintiff was in New Jersey. Defendants used interstate wire communications to disseminate. How do you know that? Use internet platforms to publish and monetize content derived from these. So basically, the wiretap goes away. Everything to me, from what I'm reading, is hinging on the wiretap. The pattern of racketeering activity is evidenced by the timing and sequencing of the defendant's publications. No, that would be like saying that I have some coordinated effort with all the other platforms that have been talking about this lawsuit. There is no coordinated effort. This is interesting. It's hot in the algorithm. I decided I want to talk about it. It doesn't work. Because, right, we need two predicated acts, right? To establish RICO, da 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 da. At least two predicate acts committed within a 10-year period. The wiretapping, which I think everybody's missing this. They're more concerned about the defamation because that's the more salacious and, whatever. I'm going to ask you to look at the more boring one. Because if violation of the Wiretap Act is tossed out, the RICO gets tossed out. Now we're only on defamation. RICO is fairly serious. The wiretap as a part of the RICO, and then the dissemination. What is this? Racketeering is evidenced by the sharing and referencing of unlawfully. Pattern is evidenced by the forwarding of emails explicitly referencing. Yeah, that's a lot. Racketeering activity is evidenced by cross promotion, repetition, amplification of defamatory statements across multiple platforms. Dude, you'd have to prove that everybody said, come on now. That's done all the time. How many people take other people's YouTube, you know what I'm saying? Their broadcast, their videos, and then they make commentary on it. That's amplifying it. They don't know them people. They don't even like them people. In intentional galvanizing of bloggers with anti-plaintiff agendas. Wow. And testimony from participants describing coordination nature. Who snitched? Evidence supports a coordinated campaign involving documented financial transactions, sequential deployment of operatives. Wow, this is serious. Insider testimony, and a self-identified ringleader whose stated goal was to end the plaintiff. Predicate acts. What's the other predicate act? Is it the monetization? Okay, so this is against. Oh, okay. I'm not going through all this. This is just too much. So is he doing RICO? No, he's only doing defamation. CTV's got defamation. James Singletary has defamation. Now that he may have because of these two statements that Bishop has been queer his whole time that goes back 40 years and asked Isaac Jordan because there was something that happened. Mad Church, you cannot go here on October 17th. If the predicate act happened on November 4th, the wiretapping, you can't go back to October 17th and say that any defamatory statements based on these future calls that hadn't happened yet. What the hell? I mean, listen, he didn't learn nothing. Against Larry and Justin Edwards, dissemination, that's defamation. I don't know, man. The civil conspiracy. So he's saying Reed, Edwards, and Blake did the RICO. Civil conspiracy. Da 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 da. I'm looking for where are the exhibits? Where are the exhibits? Prayer for relief. Oh, here we go. No less than $10 million. I'm sorry. First cause of action, the Wiretap Act, $10 million. Second cause of action, the RICO, $10 million. Third cause of action, $10 million. Fourth cause of action, $10 million. Fifth, $10 million. Child, if you don't stop playing with me. So ain't they listen, I'm used to seeing these things, but they got the child, they need to stop playing with my emotions. Okay, this is what I'm looking at. Defamation is the publication of a false statement of fact presented as true that damages someone's reputation. To win a defamation case, you have to prove the statement was false, not just hurtful, not just private, false. Truth is an absolute defense to defamation. If someone says something about you and it's true, you cannot win a defamation case, period. If somebody said that he owed $400,000 to the IRS and he owed $400,000 to the IRS, it's not defamation. If someone said that in these recordings, he said X, Y, and Z, and he said X, Y, and Z, and not A, B, and C, that's truth. That's not defamation. If the other party said you did X, Y, and Z, and then you say, I'm sorry for that as a plaintiff, or you say, I understand, I apologize, please forgive me, you acknowledge it in any way, shape, form, or fashion on that phone call, it's no longer defamation. And you have to have actual malice. Means the defendant either knew the statement was false when they made it, or they made it with reckless disregard for what was true or false. That is a heavy burden, and it's meant to be. The First Amendment is supposed to protect robust public debate, even about public figures, even when the debate is harsh. Now, there are some serious accusations being made here about child essay and things of that nature. But, and so I'm not saying that they're not, because this is serious stuff. But the dividing line is the plaintiff's team has to navigate this carefully. If a recording exists and if what on the recording is accurately characterized, that is exposure, not defamation. The plaintiff is not going to be able to win a defamation claim based on true statements, even deeply private ones. I don't know what's on these recordings. I haven't personally heard them. I'm just telling you what the law says. The law says that if the statements are made on those recordings, even if they're true, then that's a wrap. The case only becomes defamation where the defendants allegedly went further than the recordings, adding any allegations, fabricating context, or misrepresenting what the recordings can actually prove. Okay. Now, that why I told you the Singletary one, I don't know. I have to go back and look and see where this man said these things. That would be the one that I would be like, I'm a little concerned about. Because I do believe that CTV, and I do believe that the Thais report, because he doesn't want to be involved in no damn litigation. Child, he ain't got no, he don't want that. So I do believe them for sure. Mad Church Disease as well. Like I know them. I don't know them, but I'm just saying they don't want to be involved in all this kind of stuff, right? And CTV has been well trained, right? And has learned a lot by observing and then studying. And also Larry's gonna come up to the line, but he ain't gonna go over it. Right? Thank you, Kitty. So my point is that there's some people I don't know in this mix, right? But the ones that I do know or know of, they're gonna come up to the line, but they're not gonna cross it. So if these things were not said on those recordings, I can just about guarantee you, I can't guarantee everything, but I would be shocked if they misrepresented what was on those recordings. I would be shocked and shooketh. You guys like the video? I'm gonna chop this up and we're gonna put it into little bits and bobs later on. Thanks for hanging with me. I didn't intend to be on here for 2 hours tonight, but I needed to be. And y'all, hype it up, do whatever you need to do. Give me a little something, okay? Give me a little something. Now let's talk about the RICO real quick, then I'm gonna let y'all go. Now they also are bringing RICO. This one really. To state a civil RICO claim, a plaintiff must allege there's an enterprise, a pattern of racketeering activity consistent of at least 2 predicate acts within 10 years, and injury to business or property caused by that pattern. The complaint identifies the predicate acts as violation of the wiretap statute and wire fraud. That's why I was having trouble looking for that. The wire fraud theory is that the defendants used interstate communications, phone lines, internet platforms, and paywall services to execute a coordinated scheme to extract money and notoriety at the plaintiff's expense. Civil RICO claims in this case face significant hurdles. The courts don't just say, yep, it's RICO. Okay. Especially when it's basically business disputes or reputational torts. So he's going to have to, the plaintiff in this case is going to have to show that there was an actual enterprise that had continuity and structure beyond the individual bad acts alleged. That's a challenge. And like I've been saying over and over and over, these people don't F with each other. I don't know if Thais and Mad Church Disease, I don't know if they, are cool with one another. I just know that prior to October of last year, really is when this all really hit the fan. Was, in mid to late, maybe it was early fall of last year. I don't know, about 4 or 5 months ago, when it came out that Larry and Bishop have parted ways. That's when it really hit the fan. Prior to that, if you look at anything, them folks was dogging out Larry and Bishop like 40 going north, along with commentary on the rest of the Black church sector. Now, every once in a while, like a King Jives would come together with Larry when the dude in New York was going through the bling bishop, or you remember the man that said he had got robbed in his church and all that kind of stuff. When that man, they kind of came together, but then they parted ways again. So there's sometimes it's a coming together, but there's usually a parting of ways. So I'm just talking about the strategically from a lay person's observations. you're going to have a really hard time showing that there was an enterprise that had continuity and structure beyond the individual bad acts. Now, but the value of the RICO claim, even if it doesn't survive, is the damages provision. So if a civil RICO claim succeeds, the plaintiff can recover 3 times the actual damages plus attorney fees. So if they make it, cool. If they don't, not cool. I personally, I'm telling you, and I haven't heard anybody else say this, it's going to be the wiretapping for sure. If you're going to tear down either bad act, because maybe you can loosey goosey say everybody kind of got together after the fact, and maybe you can loosey goosey say, you know, somebody sent an email to a number of different people, BCC'd, and maybe there's somebody, because you did notice there was one spot in there where William McRae was mentioned, but he's not one of the defendants. I'm going to look at this again, but I don't believe that the man is one of the defendants. And he's not. But he was mentioned as a defendant. That tells me that he was potentially about to be mentioned, that he was potentially about to be one of the people that was on the defendant list. So why is he not on this defendant list? Granted, there's John and Jane Does. Is he one of the John or Jane Does? And if this was criminal, it'd be an unindicted co-conspirator, unlisted. If you give me information, I'm just making some suppositions. I'm just making some, I don't know, but I know his name listed. That's interesting, but he's not a defendant. So was he part of this email chain that then received information? But then you'd have to, I don't see, and this is no shade to him, I don't see CTV just up and wanting to work with Mad Church Disease or Thais. I just don't. He's a very independent person. He's a very independent content creator. Always has been. I don't see that. I don't see that. So you're gonna have a hard time holding this enterprise together. But you're really gonna have I think you're gonna have a hard time with the wiretap. Because if New Jersey law says that the person in New Jersey, doesn't even have to be the person that consents, it could be the other party. I think you're going to have a hard time. And you're going to also have a hard time proving that they recorded these things for the intent of committing a criminal act. What criminal act? Because defamation is civil. What criminal act? As far as I know, the audio hasn't been leaked to like major news outlets or even like gospel news outlets or anything like that. So because this audio hasn't been leaked to a TMZ or something like that, you and I ain't heard them. Have you heard them? I ain't heard them. What criminal act? Did they write you and say, I'm going to disseminate this unless you pay me $10 million? What criminal act? You have a hard time with that one. You're going to have a hard time with that one. All right. So where is this going from here? The case is in New Jersey now. Defendants have not yet been formally served or filed answers because now they have to be reserved in New Jersey. Once they're served, we'll see another round of motions to dismiss, most likely, challenging specific counts and legal sufficiency grounds. The RICO claim is most likely going to be challenged, as it should. The wiretap claim is going to face some serious consent law conflict arguments, which I think is going to shape how a lot of YouTubers, or should I say new media, bloggers and such, do business. And I think you and I need to know this just in general. And we need to really be, can we just say something, y'all? This make me not be wanting to have a conversation with people that I don't know intimately on the damn phone. Like, you can't get me on the phone. I'd rather control the narrative by writing whatever I need to write and then call it a day. Because I don't feel like I could trust a lot of y'all. Not y'all. I could trust y'all. But you understand what I'm saying? I don't know if I could trust. Like, this really is bringing up a lot of trust issues for me, personally. I'm just saying. Like, you never know if you're being recorded. So unless you really know this person intimately, and even then, like, I don't know. Anyway, the wiretap claim is going to face consent law conflict arguments, and the defamation claims will turn on the actual malice standard. So if the case survives motions to dismiss, it'll move into discovery. Then we really going to see some information, because both sides are going to have to produce the evidence. At that point, it's going to be very interesting if anybody tries to put it under seal. I don't think the defense will try to seal anything. I think if recordings exist, they enter into the record. I'm going to say that again. During the discovery phase, if the recordings exist, which they do, they will now enter the public record. If communications between defendants exist showing coordination, those get produced. They enter into the record. Discovery in a case like this could take 18 months to 2 years. It's always possible for a settlement. I don't see that happening, though. Ain't nobody settling this. Unless the not named but named defendant McCreary has some information that we don't heretofore know about. Because he ain't named, but he's named. Okay. If it goes to trial in New Jersey, it's a federal jury, New Jersey procedural rules, and a legal battle. I have to see if Jersey would broadcast it. I don't know if any federal trials are broadcast, like streamed. I'll see. The plaintiff's attorney might not have fully mapped out when they filed out in New York. So basically, this is the thing. The venue loss was fast and significant because New Jersey's now the battlefield. That changes a lot. Wiretap. Defamation claims have their strongest footing where false criminal accusations were alleged. So again, the Singletary gentleman saying whatever he said, that probably has the biggest weight, because my gut tells me that this is my opinion, that whatever was said on those audio tapes is able to be substantiated. Recordings. Yeah. So we're going to watch all that. All right, guys. You guys have been with me for a little bit over 2 hours. I really appreciate y'all. I'm going to go give me a little rest because I got things to do. We have a lot to talk about. Probably even y'all want to talk a little bit more than y'all want to talk about this a little bit more. I'm open to that. We can do that. I do want to get into people's Saturn return, so I'm going to put something out. Is it your Saturn return? Do you have Saturn in Aries? If you have Saturn in Aries in your natal chart, you have just started your Saturn return. So we're going to talk about that. I want to talk about some of the conjunctions, talk about like the revelations about aliens and things like that, and why that makes a difference. So there's a lot that I need to discuss as far as astrologically, energetically, and things like that. In the description box below, you can book a reading with me still. I have opened my readings back up. recorded or live. You can book that and pay for that there on those links. If you are thinking about opening up a business, it doesn't have to be spiritual, but if you are thinking about opening a consulting business or coaching or educational of any kind, um, reach out to me. We're using a lot more AI driven and AI assisted methodologies. And hopefully this week I will have my other channel launched so you can go and see some of those business things because honestly, we are in the next stage, right? We are in a revolution that we haven't seen, and that being like the industrial revolution where machinery and manufacturing was the biggest thing. AI is definitely, we are in the midst of it. We're in the throes of it. And if you all, we really need to get a hold of it. We need to utilize it. We need to help, allow it to help us monetize and grow. Okay. Before we're kind of phased out. So there's going to be millionaires made. And I want you all to be one of those millionaires made. Now is the best time to open up a business. Now is the best time to do like the consulting and things of that nature, education and all that. Now is the time to do it. I guarantee you now is the time to do it. We're entering another information age. All right. Okay. I'm going to get ready to get on out of here. But before I do, peace, love, blessings, and joy be unto you today, tomorrow, and for all eternity. I love you guys. I love you so much. Namaste. And listen, be careful what you say on the phone because you don't never know who's recording you, baby. All right. You don't know who's recording you, honey. So you got to be careful what's being said on that phone. Be careful what you're writing down on in the emails, and don't say nothing about nobody that ain't true. Okay, I'll talk to you later. Bye.